Hi, guys. Welcome to another segment of Legal Friday with me, Francine. So today my topic is the public domain. And why did I choose this topic? Because every day, pretty much, I'm talking to someone who stands me down, who insists that if something is on the internet, not only is it free to use, but it's free to use in whatever way they choose. Honestly, that is as far from the truth as other things I've heard today. Not, and not again. So let's talk about the public domain. Let's talk about what it is and how items get there and what you should be doing, what you should be thinking about when you consider using content that may or may not be in the public domain. So I like visuals, so let's take a look. All right, so let's start by looking at what's not in the public domain. So what's not in the public domain is any creative content that is protected by copyright. Simple answer. If it's protected by copyright, it is not in the public domain. I want to repeat that. If it is protected by copyright, it is not in the public domain. Now, not everything is protected by copyright, but if it is not in the public domain. So what is the public domain? Well, it's that place. It's that theoretical place I like to think of where you can go to get material, content that is either not protected, it never was, or it was protected and it lost its protection. But either way, if it's not protected by copyright, you don't need a license, you don't need a written document, you don't need to get permission. It is free for you to use, and it's free for you to use in whatever way you want. But the key here is to understand the difference between what is protected and what is not protected. So how does content actually get into the public domain? Well, number one, if something was generally published, prior to 1925, you can almost rest assured that it's in the public domain. However, the operative word is generally. It's always a good idea to double check. Why? Because let's suppose someone had created an article prior to 1925, but let's say they then took that article afterward and they turned it into a book, or they turned that article into a screenplay, or they turned that screenplay into some other kind of merchandise, some other product. Well, they created a derivative work based on that original copyright protected piece of work. But even though the article is in the public domain, those other items are not. So again, you want to just make sure before you assume something's in the public domain. What else is there? Items that don't have any original content. Again, keep in mind, my definition from last week is copyright protection is afforded to any original work of art or authorship that's been reduced to a tangible format. So if there's no original content, and if it's not in a fixed format, it is in the public domain. Why? Because there is no copyright protection. An example of something not in a fixed format is an idea. Ideas are never protected by copyright. Now, if you turn that idea into something tangible, some expression of that idea, and it's original, then that's protected by copyright. But otherwise, it's not protected and it's in the public domain. Also, sometimes a work of art or authorship could have had protection, but maybe it lost it. So prior to 1989, the United States was not a signatory to the Berne Convention. The Berne Convention is a copyright treaty, and several nations have signed it. We signed it, and in 1989, it went into effect. As of March 1st, 1989, if you did not have the notice symbol on your work, there was no penalty. It didn't matter. So for example, today, excuse me, if you create content and you don't put the copyright notice symbol on your work, it doesn't matter. It's not required. However, if prior to March 1st, 1989, you had creative work and you did not have that notice symbol on your work, then you lost protection. Your work immediately went into the public domain, even if you didn't realize it. If you didn't have the copyright notice symbol on your work, it was public domain work. Now, let me say this. You don't have to have the notice symbol on your work today, but it's a really smart idea. Why? Because it's you letting the world know that you lay claim to this creative, this valuable creative content. Here are three ways that the copyright notice symbol can be used. You can either spell the word copyright, so it's the word, abbreviation, or symbol for copyright, the year of first publication, and whoever owns the copyright, which could be an individual or an entity. The word copyright is spelled Copyright, not Copywrite. And I stress that because sometimes people get those confused. You know, people will use copyright, WRITE, in the place of copyright. When you use the W, it speaks to like a copywriter, someone who writes copy. It's not the same thing as what we're talking about here, copyright protection. So you can either spell the word out, you can either use the abbreviation for copyright, which is COPR, or you can use the C in the circle. Any one of those three things will work. What I sometimes see, which is very interesting, is you'll see people that have the C in the circle and the word copyright. Well, that's kind of redundant. It's copyright, copyright. You only need one. So it's either the word, the symbol, or the abbreviation. Again, it's not required, but if you created a work prior to 1989 and did not have that notice symbol, you did not have protection. That work immediately went into the public domain. And another way work gets into the public domain is if it was created by a federal government employee within the scope of their employment. Not a state employee, not a municipal government employee, but a federal government employee who creates the work within the scope of their employment. That work is in the public domain, and it's free for any of us to use in whatever way we want. So the takeaway here is make sure. Don't just assume because something's on the internet that it's free to use and there are no consequences. You want to make sure. I always think it's a better idea if you see something on the internet that you're interested in, send an email, write a letter or something to the person who owns the website asking for permission, because you never ever know. It's just better to be safe. Why? Because you may find yourself on the other side of a lawsuit. At another time, I will do a couple of videos on licenses, because licenses are really important. But in the meantime, you might want to take a look at a recent blog post I wrote on Creative Commons. I know most of you know what Creative Commons is. It's a website that actually houses a lot of images. Some of the images they provide for free, some you have to pay for. But regardless of whether they're for free or that you pay for them, you have to sign a license agreement. Well, if you go beyond the scope of that license, that's copyright infringement. And there have been several lawsuits of late where Creative Commons has sued people for going beyond the scope of that user license agreement. Again, you might want to take a look at that blog post. It's on my website, francinewart.com. Go to the blog section and you can just put into the search bar license and it'll come up. It's a recent blog post. It was published actually this month, August 2021. Okay, that's it for now. I look forward to getting your topics. You know, send me questions, send me topics that you'd like me to talk about, and I'd be happy to turn them into videos. Might not happen right away because I have a long list already, but trust me, I will get them done. So until next week, have a great weekend. Bye for now. I will see you next week for another segment of Legal Friday with me, Francine. Bye for now.